We've had the opportunity to hear from lots of you, and what we'll be presenting today is intended to bring everyone up to speed on what we know at this time about ASTs. Our information is necessarily incomplete, and you will doubtless have some experiences and information that we don't have, and we'd appreciate your sharing that today. Feel free to raise questions or share experiences during the question and answer period at the end of the webinar, or send them to us during the webinar or afterward, and we will share them with the wider group. We've been working with numerous people at the DEP, principally Ruth Porter and Joe Sizemore, and found them to be very helpful and responsive. As might be expected when implementing a new program, the DEP and we have some differences of opinion on how the AST Act should be interpreted. We are going to talk about some of those differences today and explain why we take the position we do. You can decide for yourself whether they are worth raising with the agency or not. We want to make it clear that when we take issue with the DEP's position, that these are the opinions of Mark Clark and Dave Yaussy and should not be interpreted as the position of any client we represent. It is my understanding that the WVMA may convene another meeting of interested parties and the DEP to talk about compliance and implementation issues later this year. That has not been set yet, but they will send out a notice if and when that occurs. Anyone who did not attend the August meeting but would like to be on the invitation list can email the WVMA at rebecca@wvma.com. That's REBECCA at WVMA.com. Okay, let's get started. I'm going to talk about some of the issues that have cropped up, and Mark is going to explain current enforcement trends and discuss some of the other issues that he has been seeing. First issue we have to talk about are groundwater protection plans. We have a huge disconnect with the agency on this. One of the most important points to us in industry when we were negotiating the Act was to come up with a means of proposing and implementing alternative tank practices, things like alternative secondary containment or leak detection. It was agreed that we could do that through a permit or plan amendment that was approved by the DEP. And we had the groundwater protection plans in mind as the means of making those changes. If you have an NPDES permit, you have to have a groundwater protection plan, and many people roll their stormwater pollution prevention plans, their SPCC plans, emergency response procedures, spill prevention and response plans, and GPP into one document. It was our intention to have the GPP as an enforceable document, but one that could be easily modified without having to go through a permit modification. We recently learned that the DEP takes a different approach to this. The DEP contends that the GPP is actually part of the NPDES permit, even though it's only a state-only provision. It is not a mere requirement of the permit to have a GPP. The GPP is incorporated into the NPDES permit. That means that any change to the groundwater protection plan requires a permit modification, and some changes may require major modifications. Frankly, when I learned that, it astonished me. The GPP and the Stormwater Pollution Prevention Plan contain all manner of descriptions of plants, their tanks, secondary containment, operations, practices, etc. If any change occurs at a plant, that change is supposed to be reflected in the GPP or some other document. In the past, GPPs have not been amended frequently, but presumably they will be in the future as they are given additional scrutiny by the DEP. The DEP's position would mean that even insignificant changes in your GPP will be required to keep your GPP and AST program up to date, would require a permit modification. Every time an AST changes service, every time the spill prevention and response plan changes, every time plumbing is reconfigured, a permit modification would have to be submitted. This is especially egregious to me in view of the fact that many NPDES permits are extended, and the DEP has taken a general approach, with some exceptions, that permits cannot be modified while they are extended. We pressed the DEP on this issue, and they remained adamant that without it being part of the permit, the GPP can't be enforceable. We argue that the DEP has never done this before, and in any event, there's no question that the GPP is enforceable. It's just not an NPDES permit condition. We asked why they would want us to be put into an endless paperwork cycle, especially at a time that the DEP is having trouble getting permits reissued, especially in light of the fact that we're conceding that GPPs can be enforced, just not as NPDES permit conditions. This matter is broader than just compliance with the Aboveground Storage Tank Act. There are any number of additional plans, such as the SW3P, that are required for NPDES permit holders. If all of those have to be modified as NPDES permit conditions, it's going to cause a lot of unnecessary paperwork, time, and expense. We're continuing to monitor the situation and hope to develop a workaround. Based on what we know now, though, this seems unnecessary and unwise on the DEP's part. We are going to continue to urge the DEP to take a more reasonable approach on this. A slightly different situation has arisen with regard to the application of the groundwater protection regulations at 47 CSR 48 to the oil and gas industry. We understand that the DEP has taken the position that oil and gas facilities are industrial facilities, as that term is defined in the regulations, and are subject to regulation such as the requirement for secondary containment and the need for a groundwater protection plan. However, we have the response to comments from when that rule was adopted back in 1994, where the DEP clearly agreed that oil and gas would not be included under the 47 CSR 58 groundwater protection regulations. As far as I know, the DEP is continuing to treat the oil and gas industry as subject to the rule, contrary to its earlier position. This is something we're going to continue to monitor. If you've had any experience with that, we'd be interested in knowing about it.
Just to note that we have submitted that argument in the context of a notice of violation, but have not heard a response from the DEP. So that argument is in front of them in the context of a real enforcement process.
We've had a lot of questions about tank status, and we thought it might be good to clarify them now. As a general concept, the rules provide for active, non-operational, and closed tanks. Non-operational tanks represent a special category that's set by statute. You can see the definition here, which for those who are only listening, I'll read off. Non-operational storage tank means an empty above-ground storage tank in which fluids will not be deposited or from which fluids will not be dispensed on or after the effective date of this article. End of the definition. It is not very clear, but it does not appear to apply to any tank that has held fluids after the effective date of the Act, June 6, 2014. Perhaps the legislature meant to include tanks that have held liquids after that date but will no longer be used for that purpose, but that's not what they said in this definition. This is an important point and relevant to us because non-operational tanks cannot be returned to service, and it's a categorization that tank owners should avoid. Actually, the whole category is unnecessary because a tank that truly won't be returned to service is put into closure, which we'll discuss in just a bit. As proposed, the DEP had a temporarily closed tank category. We asked that it be removed, by we, I mean industry in general, because it had all the requirements of an operating tank, and we saw no advantage to an alternative category that basically provided us no relief. I'm noting it for purposes of this webinar because we've been told that some inspectors have been arguing that any unused tank has to be closed, and one of the reasons they give is that industry's insistence on removing the temporarily closed tank designation pushed the DEP towards its present position that failure to use the tank temporarily means it must be closed. That is not the case. We have had many inquiries about moving and closing tanks. First, we would note that changing out tanks at a site without rendering them incapable of holding liquids, such as by putting a hole in them, is not a permanent closure. You may need to change the registration to show that tanks are no longer in active service, or show when they have been relocated out of their present location, but closure notification and site remediation are not triggered. One question we have posed and have not had an answer to is, once relocated back to the plant yard or even just emptied and left in place, are ASTs now held in inventory? We think that's a reasonable interpretation, and if so, they are no longer ASTs because they fall into an exemption category under the statute, and they can be deregistered. Another situation might be putting potable water in them. Again, if there's drinking water or the equivalent in an AST, that tank falls outside the definition of an AST, and you should be able to notify the DEP of a change in service and deregister. If you are permanently closing a tank, you need to give notice to the DEP of that fact, close it out in accordance with industry guidelines, and use a professional engineer or a certified person. A closure plan is required with consideration of where a release may have occurred. Note what a release is. As you see in the definition on the screen, it's a spill within secondary containment, or one that goes to waters of the state, meaning basically escapes secondary containment, or it is any spill that goes outside secondary containment, whether or not it reaches waters of the state. It should not be every drip that's occurred inside secondary containment. That's the whole purpose of secondary containment. We question whether sampling is needed to show that no release has occurred within secondary containment unless there's reason to believe that fluids have percolated through the secondary containment to groundwater or reached surface water. In this regard, we understand that the Office of Environmental Remediation was looking at closure procedures and was specifying pretty onerous sampling requirements. We have reason to believe that has changed or is in the process of being changed, but right now it is unclear exactly what is required if you want to close out a tank in place as far as determining whether a release has occurred. Closure requirements in general can be found at 47 CSR 63, section 11.3. For level 1 tanks, secondary containment must be in place next week, November 1st. There are several AST owners out there that we are aware of that cannot meet that deadline. The DEP has told us repeatedly that they are willing to develop compliance schedules for those that provide reasonable deadlines for meeting the requirements of the Act. We urge everyone who has a non-compliant secondary containment system to get a hold of the DEP as soon as possible with a plan to achieve the Act's standards. The DEP has said that there will be no penalties associated with a compliance schedule if people come forward with a plan. There may be penalties associated with inspections where secondary containment is non-compliant and there was no effort to come up with a plan and get it approved by the DEP. The same is likely true for other things like leak detection and corrosion prevention, but there are longer lead times for those and compliance plans may not be necessary. We would urge anyone who believes they cannot comply with those requirements within the time specified by the rules to contact the DEP about doing so. Notification requirements. At the AST Compliance Conference hosted by the WVMA in August, there was some confusion that arose with regard to notice requirements for AST owners. West Virginia American Water passed out a handout explaining the types of information that it would like to have from AST owners. However, that was not the notice from the DEP that is required by the statute. The DEP was to tell AST owners who to report to, and that has now occurred. You should have received that instruction from the DEP on who you should provide information to. However, if you are to report to a groundwater drinking water source, an intake that relies on groundwater instead of surface water, be sure that you are actually upgrading of the source. In some situations, the DEP may have required notice to groundwater intakes that are separated by a hydrological divide from an AST. One more point about notice. The statute sets out what information you are to give to downstream intakes and emergency responders, including information about tanks and their contents. You do not need to reinvent the wheel on this. Almost everyone will have filled out a SARA Title III Tier 2 inventory. Just send that properly redacted to protect trade secrets, just as you would file it with the state. That is sufficient under the Act to take care of your notification requirements. Let me turn it over to Mark now for some additional information.
Thank you, Dave. Yeah, I'll just note, continuing on the notification requirements, that the DEP's position is that their confirmation of registration email that was sent out last year, for the most part, constitutes that notification of who you are supposed to notify in terms of the water supply intake and the emergency response entities. And their position is that they want you to notify both the surface water supply intake company as well as the groundwater company identified on the same list, which we would take exception to, although it's a fairly minor administrative requirement. But that is something that they've indicated in their communications. We're just going to touch base on some deadlines here next, and Spilman's put together a chart of deadlines that we're happy to send out. If you want to send an email to either Dave or I, we'll get you a copy of the deadline chart, because it's a little hard to see on the screen, even if you have one. So the near-term deadlines, and we'll talk a little bit more about these topics, is, as Dave pointed out, November 1. That is the Level 1 AST secondary containment upgrade deadline. And that's the first real deadline in the rule, AST rule. Following that is a December 31st deadline for Level 1 ASTs requiring for their normal and emergency events. So normal and emergency events for Level 1 is December 31. Then the first deadline for Level 2 ASTs is for secondary containment, and that comes on February 1, 2017. The next deadline after that on upgrades is June 30, 2017, which impacts Level 2 normal and emergency events, Level 1 cathodic protection standards and corrosion standards, Level 1 overfill or spill prevention requirements, and Level 1 leak detection requirements. So those are the deadlines coming up in the near term. Basically, a lot of what we're going to talk about is DEP trying to force people to think about those deadlines. I'll just also note that effective with the rule, August 1st, were some inspection requirements related to every 14 days for inspection of secondary containment for Level 1, monthly inspection for secondary containment and Level 2 ASTs, which includes ancillary equipment up to the first point of isolation. And then your record-keeping requirements associated with those inspections is triggered. The first fit-for-service certification of inspection comes January 27th, 2017, and that's for any tanks that did not comply with the interpretive rule in the fall of 2014 or early 2015. So again, that's just a quick overview of some of those deadlines that you may want to keep in mind. So we requested from DEP through a FOIA copies of all of their inspection reports and notices of violation. And that's got a little summary here on this slide. Through the first week of August, essentially, DEP had done about 33 inspections affecting 25 separate companies, and 3 of those inspections were really due to complaints by others or thereabouts. DEP's indicated that they've inspected approximately 2,000 tanks thus far. Primarily, their emphasis is on Level 1 tanks for the most part, but they will also be inspecting Level 2 if there's a complaint, and even register and label only tanks if there's a complaint. So that's an ongoing process. They have DEP has a 3-year time period to inspect all the level 1 tanks, and so that's what the kind of schedule that they've got mapped out for themselves. Out of those inspections, there have been 9 companies receiving notices of violation. However, no civil administrative penalties have been issued yet. There's no real timetable for when they're going to begin doing that, but the likely first target of administrative penalties will be people who fail to register their tanks. Essentially, just blatantly did not register anything. Here again, as Dave mentioned, self-reporting and compliance would be an option for folks. If you come in and say, look, we didn't register and here's our registration, you have a better chance of avoiding a penalty than if you just wait and they find you however they happen to stumble upon you. This slide, again, hard to read, but DEP Inspection Checklist. This is what the inspectors appear to be using going out into the field, and they list all of the tanks and the status and the level 1, level 2, or register and label only, size of the tanks, and then construction, whether it requires corrosion protection, required records, registered and whether the tank's registered and labeled, overfill, spill prevention, ancillary equipment, and secondary containment. Those are the topics that are on the checklist. Down in the bottom left-hand corner, there's also a checklist for photographs taken, the site sketch attached, copy of regulations left on site, which I believe some of the inspectors are leaving copies of the regulations, the AST rule, suspected release issued, a check mark for that, or violations issued. So this is the, essentially, I think, their preliminary form. The next slide is the AST inspection form. And so this one is designed to tie in specific topics to regulation violations. And the list going down through there, again, you can't read it, so I'm going to read some of these. The owner or operator has failed to complete and submit an AST registration and prior to storing fluids. The owner or operator has failed to cease operations or use of an AST after July 1 that has not been properly registered or has failed to pay applicable fees. The owner or operator has failed to submit a spill plan for all regulated ASTs at the site, which was due December 9, 2015. The next one is owner-operators failed to properly label the AST with the correct signage that includes registration number, emergency contact information, and the DEP spill reporting hotline. The owner-operator failed to furnish information relating to the AST associated equipment and contents as requested by the Secretary. The owner-operator failed to ensure that the AST has secondary containment that is appropriate, and that includes adequately designed and constructed secondary containment to contain the material for a time sufficient to allow removal or disposal without additional contamination with a minimum of 72 hours. That's a significant requirement that they are pushing. The second page of that same form on the back has owner certified tank not fit for service, yes, no, not applicable, and then overfill protection, spill protection, visibly leaking external tank condition. So there are comment options for the inspectors for those.
And we'll be happy to share these forms with anybody who wants to send us an email to that effect.
Yep. And we have our email addresses at the end here in case you don't have them already. The last form that we've seen is the Spill Prevention Response Plan Checklist, and this is for use by the inspectors for those companies that have submitted spill prevention response plans. Many companies had the option of using their SPCC plans and just certifying that they have an SPCC plan. In that instance, the inspector will make a cursory review to make sure it has the right name, the right facilities, and all the tanks identified, but does not otherwise approve or evaluate further the SPCC plans that you may be relying upon. They have noted that they don't think they're really adequate and probably wouldn't be adequate for an SPCC inspector from the EPA, but they're not taking any action on that. But they are essentially using this checklist for the SPR plans, which is really modeled and follows the statutory requirements in Section 22-30-9 of the AST Act. So again, these kind of documents can help you be prepared for the inspection, which, if you have level 1 ASTs, is coming within the next 3 years, and sooner if you have an incident or somebody complains about your tank or facility. So out of these inspections, what have happened? Well, notices of violations have been identified, and these are just the topics that each of these notices of violations have covered. Essentially, DEP will issue separate notice NOV for each different topic. So registration and fees, failure to register or pay fees is the most common one. Actually, they sent out a number of NOV type reminders starting last January to any entity who had registered their tank but not paid fees, and they've indicated they had about a 98% success rate in getting those fees paid. So folks complied once they got their reminder. Next is lack of signage, label information that has been required by the statute as well since essentially the effective date. So that's one that they're very attentive to. And then secondary containment. Ensure that that there is secondary containment first of all, and because upgrading secondary containment hasn't become effective for level 1 tanks until next Monday, or level 2 tanks February of next year, they haven't really been issuing notices of violation related to failure to upgrade at this point. But this is where, as Dave pointed out earlier, they're using the groundwater protection rule to suggest that even oil and gas locations have secondary containment up to a standard of containing the fluid for 72 hours. Next item on the notices of violation is perform visual inspection. So they're checking for documentation that you inspected your secondary containment for level 1 tanks every 14 days, and then performed the monthly inspections for level 2 tanks and secondary containment, as well as the level 1 tanks. And having documentation, having your forms in order, and having that documentation available is going to make the process work a little more efficiently. Then obviously checking that you have spill prevention response plans available. If there are none or inadequate, you will essentially receive a notice that it's inadequate and have 30 days under the statute to bring this plan up to standards. Some other notices of violation. Did you provide notice to public water system and county emergency response organizations under Section 10, I believe, of the AST Act. That's, again, something that they're paying attention to in their initial inspections. Similarly, notifying emergency response entities in the event of a confirmed release. Section 6.2 of the rule requires that you notify both the DEP through their emergency spill line or number and the emergency response entities for that county. And that, if you fail to do that, they'll be focusing on that and wanting you to have that performed. One anecdotal example, a call was made to the local emergency 911 regarding a release, and the person had really very little idea with what to do with that information or who to pass it along to. So the local emergency responders are not really prepared, at least in some instances, to receive those kind of calls. But making them and creating a document that you can provide in the event of an inspection will be very helpful. Last one is closure not performed by an RPE. So if you have a release and take corrective action to clean up any fluids and remove the tank from the site, which in the case of oil and gas operators may have been suggested by the oil and gas inspector, the above-ground storage tank inspector is more likely than not to say that you closed it without following the closure requirements in section 11.3 that Dave mentioned earlier. So what if the DEP can't provide or issue a notice of violation, but they're concerned about other issues that exist on the facility? They have started using information requests in conjunction with their inspections, and it's been described as an effort to make tank owners think about compliance and anticipate these deadlines that we've mentioned and what they're going to have to do. So the language is paraphrased a little bit, but just wanted to give you an idea of what kind of information requests you may see following an inspection. Document that secondary containment is adequately designed and constructed to contain materials. So essentially what the contents are and what the secondary containment is have to be compatible. And then there have been comments that this would also require the 72-hour retention of fluids. And how to accomplish that is still not really well decided. Document the ability to comply with secondary containment, corrosion and deterioration prevention, and leak detection. So that's just throwing essentially everything into one category. And secondary containment, corrosion, and leak detection are the top 3 issues that the DEP is identifying as areas of concern. They consider those to be the most important topics that tank owners need to address and make sure that they're in compliance with. Document financial responsibility. And we'll talk about this a little bit more later, but having evidence of financial responsibility. The rule does not require that you submit it to the DEP in advance, but when they do inspections or visit your site, they can ask to see your financial responsibility, and having whatever you're going to rely upon available will help avoid an NOV or an information request. Document tank sizes, and similarly document design and construction or manufacturer's specifications for tank capacity. Apparently, if you can't demonstrate the size of a tank, they want evidence of that it's below 1,320 gallons, which would be the size of that the AST Act starts to cover. Document your ability to comply with the secondary containment requirements, more broadly stated. And again, we're concerned that they're looking for some sort of evidence that the secondary containment will hold for 72 hours. Document notification to the nearest public drinking water intake and county emergency response organizations. This is compliance with Section 10 of the AST Act. And then document construction and function of the drainage system and water treatment plant. So for facilities that have essentially a drainage system to water treatment as their secondary containment, they're going to want more than just your word that this is how it works and it's effective. More information requests. Provide registration and ownership information for all mobile tanks at the facility and how long mobile devices are at the facility. So they're essentially wanting demonstration that a mobile tank is really mobile, and if it is, it falls outside the definition of AST and does not require registration. Again, this seems to be pushing the envelope a little bit, but having some basis on which to evidence that your tanks are mobile will avoid having to go through an extra step of an information request. And then grouping the next three together, document spill and overfill requirements, normal and emergency venting, ancillary equipment compliance. All of those are included in the deadlines for upgrading that I noted earlier. And so they're, again, trying to get tank owners to think about and start working on how they're going to comply. So the responses can be, we're working on it and here's the plan. And if you're not going to comply by the deadline, again, you may want to have a conversation about a compliance schedule that is more reasonable for you. Back to financial responsibility. That's one of the significant topics, and it's a little bit of a challenge for especially some of the smaller entities. Again, it's not required to be submitted in advance, so you just need to have it there when an inspector shows up. For oil and gas entities, there was a provision that we believed allowed oil and gas entities to use their blanket bonds for the financial responsibility requirement. The DEP is taking the position that those bonds do not cover the corrective action, remediation that may be necessary in the event of a release, and that would require a change in the bond, which would require approval by the Attorney General's office. To my knowledge, nobody's undertaken that endeavor, but while blanket bonds were anticipated to be a real easy way to comply with financial responsibility, DEP is resisting that. Similarly, a letter of credit, whether for a blanket bond in oil and gas context or otherwise, may not contain language that would be covered under the AST rule and would require perhaps a bank to amend the letter of credit. Insurance. This is, one would think, would be an easy way to address compliance with financial responsibility. But the insurance policies and the DEP has indicated they'll take a look at it to make sure it covers environmental hazards, including leaks from tanks. In at least one instance that I've become aware of, the insurance company is denying coverage in a circumstance of a release, and one of their carve-outs is a release related to corrosion or that's a result of defects in materials. So if you're going to rely upon insurance for your financial responsibility, you need to be attentive to the language in the insurance and make sure it's covered, or you may be going back to your insurance company to get a new form. Other options include cash deposit, blanket bonds for oil. This again is oil and gas. Have not heard whether anybody's been denied that their financial responsibility requirement is met with a cash deposit blanket bond. That one would seem to be pretty safe. A couple of other alternatives: self-insurance or proof of assets. We don't have any real experience with that, but larger companies, it seems like, would have the ability to make that kind of demonstration, or through a form of self-insurance evidence. Oh, just to note, your financial responsibility amount is determined by calculating the capacity of your level 1 tanks times 20 cents per gallon, and for level 2 tanks, the total capacity times 10 cents per gallon. So that's how you calculate and determine the amount of financial responsibility that you must have available for your tank under the AST rule. Just sort of current event, annual operating fee invoices. We knew those were going to be sent out after the start of the effective date in August. It's my understanding that the invoices were just mailed last week, so many or most of you would have received by now the invoice for annual operating fee, and as you can see, that's $201 per level 1 AST and $40 per level 2 AST to fund the operations of the DEP so they can do more inspections and hire more people. And that covers our prepared materials, and I think we have a few questions.
We do. The first question was, do you agree having automatic tank gauging and performing inventory control count as leak detection? They certainly count as leak detection. However, they do not satisfy Section 10.3.b of the regulation, which says that the owner or operator shall ensure that the area beneath the tank bottom is monitored for leakage by visual, mechanical, or electronic leak detection methods. So that would still have to be provided. We had another question: are information requests FOIAble? Meaning, can the responses to information requests be obtained by anybody through a Freedom of Information Act request? And the answer is yes. Not aware of any exemption for the results of the information collection request.
I agree. I'm not sure under what exemption they could protect that information.
We have an observation from one people listening that AST inspectors have indicated to him that the DEP believes that earthen dikes are not adequate secondary containment. And Mark, I think, knows a little bit more about that. Before I turn it over to him, though, and before I forget, on the Wabonga fall meeting a couple weeks ago, I was asked about the exemption for tanks located at pipeline facilities. It's found in Section 3(1)J of the Act. At that time, I was not aware of anyone who had used that exemption to avoid registering an AST. I have now been told of someone who has. If this remains a matter of interest for anybody in the oil and gas midstream or transmission area, please let us know. We will try to hook you up with anybody else who shares the same interest in how that exemption is going to be applied. also was asked at the Wabonga meeting about impoundments at oil and gas drill sites. Sometimes those impoundments are put up on a temporary basis, maybe for 3 or 4 months, and then disassembled. Question was whether those are mobile tanks and therefore exempt from the Act. Based on the ones we were looking at there, those would not be mobile tanks. They would not be exempt from the Act if they're constructed on site, as opposed to being on some kind of mobile platform. With that in mind, I'll turn it back over to Mark.
Sure. Just to note that the AST inspector, I guess, taking or at least making comments that the DEP really doesn't like earth and dike secondary containment, even though it's expressly allowed in the Act. So, they really don't have a way to say you cannot use earth and dikes, but what they're doing is pressing on the secondary containment standard of 72-hour fluid retention and suggesting that you're going to have to do something to improve the permeability or impermeability of the secondary containment, which may include lifting the tank up in order to either see the underneath of it or install some impermeable secondary containment materials at the bottom. That is a very big issue for thousands of regulated tanks in the oil and gas side in particular, and that is also inconsistent with at least one comment from a DEP person while the rules were being developed, that they were not looking to have tanks lifted and moved as part of this inspection process, or leak detection, or visual testing. So that's a big issue that seems to be evolving and arising, really, that was not anticipated. Oil and gas thought their earth and dikes were basically approved. I'm going to read, because there have been, this isn't necessarily the position of the DEP, but these are comments that have been reported in different contexts that the DEP inspectors seem to have a little more aggressive view of the AST rule enforcement than at least industry was anticipating in the development of the rule. Inspector indicated that a tank that was setting on the ground would need cathodic protection or possibly raise the tank so inspections could be performed. A big surprise. A shutoff valve would need to be installed closer to the tank inside the secondary containment. That is something that everybody will want to work on, because the initial shutoff valve determines the extent of the AST for the first point of isolation. So if you have a first point of isolation outside of a secondary containment, you may want to adjust that to bring it inside the secondary containment. Otherwise, your secondary containment arguably will need to be extended to cover the piping outside of the walls. Inspector indicated that DEP doesn't favor earth and dikes. Plastic pipe dike drains are a concern. The concern is that a fire could cause the drain to melt and release the liquid from inside the dike if you have a plastic pipe released. That again I'm not sure whether that makes any sense for brine tanks, for example, or other non-flammable contents, fluid. Along the same lines, plastic liners could not be used on top of soil for the secondary containment, because that could melt in the event of a fire. So those are some of the comments that are being thrown around out there, although none of those have resulted, to our knowledge, in notices of violation or anything at this stage.
We have another question. Is there any additional guidance for differentiation between process and storage tanks? That's something that a number of manufacturers have been facing. I'll read briefly the definition of a process vessel. Process vessel means a tank that forms an integral part of a production process through which there is a steady, variable, recurring, or intermittent flow of materials during the operation of the process, or in which a biological, chemical, or physical change in the material occurs. This does not include tanks used for storage of materials prior to their introduction to the production process or for the storage of finished products or byproducts of the production process. One of the differences of opinion we've had with the DEP is whether what we call a wide spot in the line is a process vessel. In other words, if you have a place where fluids are stored but there isn't any chemical, physical, or biological change occurring, whether that is a process vessel. We've taken the position that as long as there is a flow through that tank as part of the production process, it's a process vessel, not a storage tank. Storage tanks are at the beginning or the end of the process. So we know the DEP is still working through that. I'm not sure they've told us that's not the case, but it certainly wasn't how they were interpreting it initially.
Just a couple other sort of miscellaneous notes, and again, this is another anecdote that was a little bit surprising, that they're regarding a release inside secondary containment from a tank. It was an oil release, and the secondary containment was holding it, and the DEP's Office of Remediation basically instructed the tank owner not to touch anything until a cleanup plan is written and approved, which is under the release requirements in the rule, which is, would appear to be inconsistent with the initial requirement of taking emergency measures to protect the environment and human health. Certainly a curious and troubling position that they're taking in that one instance, and perhaps not the policy of the DEP.
I had another question. Are there guidelines or experience for concrete secondary containment meeting or not meeting the 10 to the minus 7 centimeter per second permeability requirements? I am not aware. I know that presents a problem for some folks, for those putting in new secondary containment, but I'm not aware of any guidelines.
I am not either. I'm trying to remember whether there's some SPCC language that might be helpful in that regard, but that's part of this, the evolving secondary containment requirements. I'll note, sort of in that context, that how you calculate the volume or the area of secondary containment has been questioned by certain tank owners, and the DEP has indicated that and this is in the context of freeboard and storm events, that the DEP is not requiring necessarily the 25-year, 24-hour storm event freeboard capacity as part of the calculation of your volume. That the 110%, as long as it's coupled with some frequent inspection or other operational requirements, is probably acceptable. So that's a very detailed point, but something that is being looked at.
We have one last question. That is, what is a suspected or threatened release, and when is notification required? That is section 2.63 of the rule, and that Mark was smiling at me because that is one we've gone back and forth with the DEP over. I think it's fair to say that they believe anytime you have an unusual situation at a tank and think that it could possibly be due to something leaving the tank, you have to report that to them. we feel that A, that's not necessary, and that B, a suspected release means some type of the fluid has migrated outside secondary containment, or it has left was in secondary containment but has reached waters of the state, and that's necessary before there's any kind of report. But if you want to not run afoul of the DEP, you would have to report everything that you think could indicate the possibility of a release.
Well, in that context, Section 6.2 requires, upon the occurrence of a confirmed release, that you report to the DEP's hotline as well as the local or county emergency management agencies. I think it's a confusing area. It's really, the definition is pretty vague. I think if you have real evidence of something coming out, you just don't know why, that it requires an investigation at minimum, and then you document. I think you document the results of it. If you don't think there's any evidence of a confirmed release, I'm not sure that you have to report that, but that's going to be up to the individual tank owner and your risk tolerance.
Well, that's an important clarification. This brings us to the conclusion of today's webinar. Thank you very much for listening to us.